All right, ladies and gentlemen, this hearing of the United States Commission on Civil Rights will come to order. Our purpose today is to collect facts and information regarding the Department of Justice's actions related to the new Black Panther Party litigation and its enforcement of Section 11B of the Voting Rights Act. The Commission began its investigation of this matter almost a year ago in June of 2009 and held the first hearing on this matter on April 23, 2010. During this hearing, the Commission heard testimony from various fact witnesses who testified, who witnessed the Election Day incident, as well as Representative Frank Wolf and former DOJ official Gregory Katsas. Today's testimony by Assistant Attorney General for the Civil Rights Division, Thomas Perez, is a continuation of that hearing. By now, the facts of this case should be well known. On November 4th, 2008, two members of the new Black Panther Party appeared at a at a polling station in Philadelphia. Video evidence and eyewitness testimony show that these two members standing athwart at the entrance of the polling place, dressed in paramilitary uniforms with black combat boots. One of them brandished a nightstick. They hurled racial epithets at white and blacks alike, taunting poll watchers and poll observers who were there to aid voters. And according to evidence adduced during our hearing last month, caused some voters who sought to cast their votes that day to turn and leave the polling place rather than have to contend with them. A black poll worker who happened to be working for the Republican Party was called a race traitor and promised that there would be hell to pay if he emerged from the polling place, according to eyewitness statements. He was so alarmed by the Panthers' presence that he would not leave the polling place until they left. Initially, this assault upon the sanctity of the polling place was aggressively pursued by the Justice Department in 2008 under Section 111B of the Voting Rights Act, which prohibits any person, whether or not acting under color of state law, from intimidating, threatening, coercing, or attempting to intimidate, threaten, or coerce any person from voting or attempting to vote, or from aiding a voter. The department's lawsuit sought to permanently enjoin any similar future conduct by four defendants: Minister King Shamir Shabazz, Jerry Jackson. These are the two gentlemen who were at the polling place on the day in question, and the new Black Panther Party chairman, Malik Zulu Shabazz, and the organization itself. None of the defendants contested the charges, and all that remained for the department to do was to seek an entry of default judgment and an injunction to stop future acts of intimidation. But on the eve of the date which the court set for the department's request for default judgment, the trial attorneys that had vigorously pursued the case were instructed instead to request a continuance by then acting Assistant Attorney General for Civil Rights, Loretta King. In the days that followed, and despite the robust justification memo it had prepared at the inception of the case to support its request to file suit, it appears the experienced line career attorneys responsible for the case were put under intense pressure to justify the lawsuit against the Panthers and required to prepare a defense of its proposed injunction, as press reports and evidence submitted into the record by Representative Wolf during last month's hearing demonstrate. Ms. King then sought a review of the matter by the division's appellate section, which was also entered into evidence by Representative Wolf. That review states that the department can make a reasonable argument in favor of default relief against all defendants, and probably should, given the unusual procedural situation. It was a view shared by a total of at least 6 career attorneys intimately familiar with the details of the case, including 2 who opined from the appellate section. One of the appellate attorneys went so far as to characterize the injunctive relief against King Shamir Shabazz and Jerry Jackson as very limited, and acknowledged that such a limited injunction will not accomplish very much. Nevertheless, the department dropped its claims against 3 of the defendants: the organization, the new Black Panther Party, its chairman, Malik Shabazz, and also, curiously enough, Jerry Jackson, who was one of the individuals from the organization who were at the polling place acting in concert with the gentleman who wielded the nightstick. As to King Shamir Shabazz, the department reduced the injunctive relief it sought against him, whereas the original complaint sought an unlimited injunction prohibiting acts of intimidation anywhere in the United States. The final relief sought by the department was limited solely to the city of Philadelphia and was only to last through November of 2012. Careful analysis of the department's action in this case falls squarely within this commission's special statutory mandate to assess the enforcement of the Voting Rights Act. That act resulted in large part from the commission's earliest work in the 50s. This assessment comes at a time when both the President and senior DOJ officials have announced the department is prosecuting civil rights violations again and that it is back open for business. Mr. Perez has stated that it is the job of the Civil Rights Division to enforce all civil rights laws and has noted, quote, civil rights enforcement is not like the buffet line at the cafeteria. You can't pick and choose which laws you like and which ones you don't, close quote. He has pledged to enforce those laws in a fair and independent fashion using all the tools at the department's disposal. Quote, we are not simply open for business, Mr. Perez has said. We are doing business in a new, different, and better ways, close quote. Close quote. In testimony before the House Judiciary Subcommittee on the Constitution in December of 2009, Mr. Perez identified the voting rights of all Americans as being at the core of equal opportunity and equal justice. Robust enforcement of civil rights laws and the dispensation of equal justice, regardless of the color of the victim or offender, are at the heart of the new Black Panther Party case. The dismissal of this case is critical because of the broader message it conveys. The American people expect the Department of Justice to vigorously enforce the nation's civil rights laws. Doing so requires it to exercise its discretion to send a strong message to hate groups across America that the kind of behavior that occurred at the polling place in Philadelphia on Election Day will not be tolerated. Rather than exercise its discretion to deter this behavior in the future, it declined to follow the collective wisdom of career attorneys from several components of the department, weaken the remedy it sought, and reduce the number of defendants it sought any remedy against just to one individual, despite evidence that, at a minimum, he acted in close coordination with his colleague, Mr. Jackson. A policy of non-prosecution when the facts are so clear is likely to lead to disrespect for the law and the department that is charged with enforcing it. Mr. Perez has said that the nation needs a civil rights division because it is the moral compass of our nation. It serves a guiding light as we navigate new paths on the road to equal justice. Well, if the Civil Rights Division is the nation's moral compass, the Commission on Civil Rights is its conscience, and it is our duty to ensure that the moral compass is pointing due north. Before we hear testimony from Mr. Perez, each commissioner has been given a minute in which to make an opening statement if he or she wishes. If a commissioner would prefer to reserve his or her time for a closing statement, they are free to do so. We will adhere firmly to this time limit. Vice Chair Thurmstrom, please proceed.
Point of information. I think overrides.
Yes.
I just had a question about a statement made in the chairman's opening remarks. You talked about the
Commissioner Yaki, we are under tight time constraints.
I understand, but I think this is important because
it may be important.
It goes to the rules of the game here, which is you talked about the so-called terrified poll worker
Commissioner
at
Yaki,
the facility.
Commissioner
Yaki,
Yaki,
we have no direct evidence.
Commissioner Yaki, we will not be doing this now. Vice Chair Thurmstrom, please proceed.
I'm asking for clarification, Mr. Chair.
Vice Chair,
you made a statement
Vice
in your
Chair
thing,
Thurmstrom,
which is not based on any direct evidence by anyone here. It is hearsay testimony. The only
Commissioner Yaki, now is not the time to try to run out the clock.
I'm not trying to run out the clock. I'm simply saying that the only direct testimony.
Commissioner Yaki. Commissioner Yaki, you are wasting valuable time, and you know it.
And I think that your 10-minute statement, we only get 1 minute, is a way for you to put in facts and evidence which do not exist.
Commissioner Yaki, Commissioner Yaki.
That's all I have to say.
Commissioner Yaki, if this happens again, it will come out of your time.
Oh, you can do whatever you want, Mr. Chair.
Vice Chair Thurmstrom, please proceed.
Well, since I was interested in this, I'm going to reserve my time for later.
Okay. Next up, Commissioner Gaziano.
Oh, I think, wouldn't it be Commissioner?
Actually, we're reversing the order.
I'll reserve my time as well.
Okay. Commissioner Yaki.
I reserve my time.
Commissioner Melendez, are you on the phone?
Yes. I just wanted to thank Mr. Perez for being here, and that's about it.
Okay. Commissioner Harriet.
I'll reserve my time for afterwards.
Okay. I will do the same. At this time, we'd like to welcome... oh, I'm sorry.
I'll reserve my time also.
Okay, we'd like to welcome the Assistant Attorney General for the Civil Rights Division, Mr. Thomas Perez.